Is Edu Manzano a Filipino citizen? Watch till the end, because this landmark case in 1999 will reveal the truth that fundamentally redefined what it means to hold dual citizenship in the Philippines. The year is 1998, and the vibrant city of Makati is buzzing with election fever. The race for vice mayor is incredibly close, with 3 candidates vying for the position: Ernesto S. Mercado, Gabriel V. Daza III, and the ultimately front-running Eduardo B. Manzano. As the votes are meticulously tallied, Manzano, a popular personality, secures the highest number, beating Mercado by a narrow but significant margin, while Daza placed 3rd. But just as victory seems assured for Manzano and the city awaits his proclamation, a dark cloud appears. His proclamation is suddenly suspended. Why? Because a petition for his disqualification has just been filed. The reason for the suspension is a bombshell. The petition filed by a certain Ernesto Mamaril alleges that Eduardo Manzano isn't a Filipino citizen at all, but rather an American citizen. Manzano himself readily admits to being registered as a foreigner with the Bureau of Immigration, even holding an alien certificate of registration. However, he strongly maintains that he is a natural-born Filipino citizen. He was born in San Francisco, California in 1955 to 2 Filipino parents. While U.S. law, under the principle of jus soli, right of soil, considered him an American citizen at birth, Philippine law, based on jus sanguinis, right of blood, recognized him as Filipino because of his parents. This unique situation placed him squarely in a state of dual citizenship from birth. The case first landed before the 2nd Division of the Commission on Elections. After reviewing the facts, the 2nd Division sided with the petitioner. In a resolution dated May 7, 1998, they declared Eduardo Manzano disqualified from running for vice mayor. Their reasoning was straightforward. Section 40D of the Local Government Code explicitly states that those holding dual citizenship are disqualified from running for any elective local position. Since Manzano was considered a citizen of both the Philippines and the United States, the COMELEC 2nd Division concluded that he fell under this disqualification. But Manzano wasn't giving up. He immediately filed a motion for reconsideration with the COMELEC en banc. While this motion was pending, the elections went ahead, and Manzano still secured the highest number of votes. Seeing an opportunity, Ernesto Mercado, the 2nd-placing candidate, sought to intervene in the disqualification case. Months later, on August 31, 1998, the COMELEC en banc delivered its ruling by a vote of 4-1. They reversed the 2nd Division's ruling and declared Manzano qualified. This decision paved the way for his immediate proclamation as vice mayor. Unwilling to accept this, Ernesto Mercado swiftly elevated the battle to the highest court in the land, filing a petition for certiorari with the Supreme Court, seeking to overturn the COMELEC en banc's decision and finally disqualify Manzano. The main issue in this case is whether or not Eduardo B. Manzano, who was a dual citizen by birth, is qualified in running for and holding the elective office of Vice Mayor of Makati City under Section 40D of the Local Government Code. The Supreme Court meticulously analyzed the arguments, beginning with the question of Mercado's legal standing to sue. The court confirmed that Mercado, as a rival candidate whose proclamation was yet to occur, had a legitimate interest in the case, thus affirming his right to bring the suit. Then the court dove into the core of the matter, the meaning of dual citizenship as a ground for disqualification. The Supreme Court made a significant distinction. To begin with, dual citizenship is different from dual allegiance. The former arises when, as a result of the concurrent application of the different laws of 2 or more states, a person is simultaneously considered a national by the said states. This, the court explained, is often involuntary, an unavoidable consequence of conflicting laws of different states. On the other hand, dual allegiance refers to the situation in which a person simultaneously owes, by some positive act, loyalty to 2 or more states. While dual citizenship is involuntary, dual allegiance is the result of an individual's volition. This distinction was key, as the Constitutional Commission's intent was to combat voluntary dual allegiance, which is inimical to the national interest, not involuntary dual citizenship. Based on this crucial distinction, the Supreme Court declared that the phrase dual citizenship in Section 40D of the Local Government Code must be understood as referring to dual allegiance. The court unequivocally stated, consequently, persons with mere dual citizenship do not fall under this disqualification. For candidates who possess mere dual citizenship by birth, the court ruled that it is sufficient if, upon filing their certificates of candidacy, they elect Philippine citizenship to terminate their status as persons with dual citizenship. The act of electing Philippine citizenship would, at the same time, forswear allegiance to the other country and thereby terminate their status as dual citizens. The court emphasized that whether the foreign state recognizes this renunciation is irrelevant under Philippine law. It quoted a relevant case. No foreign law may or should interfere with its operation and application. If the requirement of the Chinese law of nationality were to be read into our naturalization law, we would be applying not what our legislative department has deemed it wise to require, but what a foreign government has thought or intended to exact. That, of course, is absurd. Thus, applying this reasoning to Eduardo Manzano's case, the Supreme Court found that by filing his certificate of candidacy on March 27, 1998, he had indeed effectively elected Philippine citizenship, and in doing so, renounced his American citizenship. The court highlighted Manzano's sworn statements in his certificate of candidacy, including, "I am a Filipino citizen natural born," and crucially, "I am not a permanent resident of or immigrant to a foreign country," followed by his pledge, "I will support and defend the Constitution of the Philippines and will maintain true faith and allegiance thereto, and that I impose this obligation upon myself voluntarily without mental reservation or purpose of evasion." The court concluded that these solemn declarations were sufficient to remove any disqualification he might have had as a dual citizen, drawing parallels to the Frivaldo versus Kamalek case, where taking an oath of allegiance in a certificate of candidacy was deemed a sufficient act of renunciation of foreign nationality. Finally, the court further solidified its decision by looking beyond just the paperwork. It noted Manzano's life choices. Private respondent's oath of allegiance to the Philippines, when considered with the fact that he has spent his youth and adulthood, received his education, practiced his profession as an artist, and taken part in past elections in this country, leaves no doubt of his election of Philippine citizenship. The Supreme Court ultimately ruled that Manzano's declarations were made on the faith that he would uphold his undertaking. They warned that should he betray this trust, there are sufficient legal sanctions for declaring the loss of his Philippine citizenship through expatriation. Thus, the Supreme Court dismissed the petition for certiorari for lack of merit, affirming Eduardo Manzano's qualification to serve as vice mayor of Makati City.